The Law School Admission Council has been sued. The organization that runs the LSAT, the Credential Assembly Service, and the entire law school application system is now facing a federal class action antitrust lawsuit. And it's not about whether the LSAT's fair or about logic games or about admission standards. It's about who controls the only gateway into law school. Because the allegation here is pretty simple. The system that law school applicants are forced to use is structured in a way that keeps prices high, shuts out competition, and puts the entire cost of applying on applicants, even though law schools are the ones using the system. That's what's being alleged, and that's what's being challenged. And if this case survives, it could force real changes to how law school admissions works. So today I want to walk you through what's actually going on here, because once you understand how this system is set up, it changes how you see the entire process. Now let's talk about what the LSAC actually does. It is a nonprofit membership organization that's been around since the late 1940s, and more than 200 law schools in the US and Canada are members. And LSAC controls three things that matter a lot if you're applying to law school: the LSAT, the Credential Assembly Service, aka CAS, and the centralized platform law schools use to receive and process applications. From the outside, this looks pretty reasonable. You've got one login, one place for transcripts, one place for rec letters, and one system schools can rely on. And from an administrative perspective, it's pretty efficient. There's no argument there. But most applicants aren't mad that it's centralized. But what matters is how the system is paid for and who actually controls it. Now, here is the core allegation in the lawsuit, and this is the part that makes people stop and go, wait, what? Because law schools do not pay to use the application platform. They get a fully integrated, fully built admission system with document management, communications tools, reporting dashboards, without paying any of the licensing or usage fees that you would expect in a normal software market. So where does the money come from? It comes from you, the applicant. According to the complaint, applicant fees are the only fees paid by anybody for the entire law school application platform. Well, let me say this plainly. Applicants fund the system, but law schools control the system, and applicants are not allowed to use anything else. That is the structure being challenged here. It's all about incentives. Now, if you've already applied to law school, you already know how the fees feel. You pay upfront just to open your application file, and then you pay again for every school you apply to. And then most schools charge their own application fees on top of all that. If you apply to a normal number of schools, not even an extreme number, you could easily spend over $1,000 before you get a single decision back. And of course, none of this is refundable. But the lawsuit isn't saying that high fees are automatically illegal. What it's saying is that mandatory, unavoidable fees imposed through a system controlled by the same institutions that benefit from it may violate federal antitrust law. And that is a very different argument. So why does antitrust law even come into this? It's meant to stop two things that matter here. The first is price fixing, the other is monopolies. Now, price fixing doesn't mean that people are sitting around in a room plotting. It can happen when institutions coordinate through a central system to impose uniform prices that consumers cannot avoid. Monopoly law looks at control, who owns the market, and whether competitors are effectively shut out. And this lawsuit says both are happening here. And here's the detail that most applicants never realize. LSAC is not some neutral third party. It's not a government agency. It's a membership organization governed by law schools themselves. Now, according to the complaint, everyone on the board works for a member law school. So the same institutions that require applicants to use this system are also involved in governing the system, including how it operates and how it's priced. Now, here's the easiest way to think about this. Imagine that every major employer required job applicants to apply through one platform. Applicants pay per submission, and the platform is governed by the companies doing the hiring. Even if it's efficient, that's not a competitive market. And that's what this lawsuit is asking courts to look at. And here's why closed markets matter. In a normal competitive market, providers compete on price, on experience, and on innovation. But here, every law school uses the same platform with the same structure, the same per school fees, and there are no alternatives. And when there's no competition, there is no pressure to improve or to lower costs. That's why applicants don't ask, which schools am I competitive for? They ask, how many schools can I afford to apply to? And that question alone tells you that something is off. Access to legal education shouldn't come down to how many fees you can pay. Now, there's one important thing to say here. This is not the only way admission systems can work. Undergraduate admissions uses centralized platforms where schools pay to participate. And business schools use decentralized systems. Some charge modest fees, some waive them entirely. And even law schools sometimes waive their own application fees. But almost none waive the platform fees, because every member law school requires applicants to use the same system. There is no alternative. And that exclusivity is what turns a centralized system into a closed one. Now, to be fair, centralization does have its benefits. It reduces administrative chaos. It standardizes records. It helps schools compare applicants efficiently, and it can reduce fraud and verification issues. And even if this lawsuit succeeds, change wouldn't automatically mean lower costs overnight. If costs shift to the law schools, schools might pass those costs back to applicants in other ways, like higher school-specific fees, new admin charges, things like that. So I'm not saying this is a simple good guys versus bad guys story. It's a question about the costs and how power are structured and who bears the burden. So this lawsuit right now is procedurally at an early but important stage. LSAC has almost certainly filed a motion to dismiss. And even if we assume everything the plaintiffs are saying is true for now, the question is, does this lawsuit legally hold together? A lot of class actions end right there. And if this case is dismissed, the system will stay exactly the same. But if the case survives, discovery begins. And discovery is where things get real, because then they're going to disclose emails, financial records, governance documents, contracts, and that's when the structure of this system actually becomes visible. Now, there's a hearing scheduled soon to decide whether the case will move forward. That hearing doesn't decide who wins, though. It decides whether the case gets to continue. And the same plaintiff's law firm has filed a similar antitrust lawsuit challenging the medical school admission system. And that matters because this suggests it's not just about law schools. It's about centralized admission systems more broadly, especially when costs are pushed entirely onto the applicants. And so there are a few different things that could realistically happen at this stage. This case could get dismissed early. That happens all the time. It could survive and then settle. That's very common in big structural cases. Or a settlement could mean lower platform fees, expanded fee waivers, governance changes, or limited alternatives. Or, less likely, but perhaps higher impact, the plaintiffs could win meaningful relief in court, which could force changes to how the system operates. And of course, none of this is guaranteed, but for the first time, these questions are being asked seriously in a federal court. Now, as an applicant right now in 2026, you don't want to wait for the courts to fix anything. You want to decide your personal application budget early, be proactive about fee waivers, treat them as part of the process, and apply with purpose. Every school should be on your list for a clear reason. And this lawsuit matters, but it's not a timeline that you should plan your life around. But the bigger takeaway is that this lawsuit is forcing a question. Is the current structure the only way that admissions could work? Or is it just the way it's always worked, but it could change going forward? For now, your process remains the same. Get the highest LSAT score you can, get into the best law school you can with as much scholarship money as you can get a discount on your tuition, minimize your debt, Best way to do that is through the LSAT.